I demand a speedy trial. What a powerful phrase. But what does it really mean? In this video, I'm going to talk about your sources of speedy trial rights, namely constitutional speedy trial. So if you're watching outside of Maryland, that part might be applicable to you. And then I'm going to talk about Maryland's statutory speedy trial right, we also call our Hicks date. These two are often confused, so I'm going to break the video in half and sort of say this is the point where I'm switching gears. Let's jump right into it. What are your constitutional rights to a speedy trial? Well, the Sixth Amendment of the U.S. Constitution says you've got a right to a speedy trial, but until a judge interpreted that, it doesn't really mean a whole lot. So, the case that we often look to is the Barker v. Wingo case. And it created a four-step test, a four-pronged test, a balancing test, as to whether or not speedy trial has been violated. It's a case-by-case analysis, but the four factors generally are the length of the delay. So we're looking if there's been a delay of constitutional dimension, courts have called it. But generally here we're talking more than a year sometimes. The reason for the delay. So is the reason DNA analysis, blood analysis, experts, unavailability of witnesses, child witnesses, court scheduling, you name it, there's been a case on it. The time and manner in which defendants assert his right. Generally speaking, most lawyers demand a speedy trial in some fashion when you hire them, but what if you're on your own for a portion of the case? And can your lack of a demand excuse extraordinary delay? Courts have opined on this. Finally, the degree of prejudice it's actually caused you. So were you incarcerated? Has a witness vanished into thin air because they've waited so long for trial? Things like that. So that's the constitutional side of things, and that is very fact specific. So it might depend on how long the delay was, if there was a good enough reason, whether or not you demanded a speedy trial, and then also how it has affected you, if at all, pending your trial. Now let's jump into the Maryland specific side of things, and this is where it gets a little bit more confusing. Now we're talking about your Hicks date. And if you're watching this video and you're charged with a crime in Maryland, you need to know that you do not get a Hicks date unless your case is in the circuit court. So if your case is in the district court, you've still got those constitutional speedy trial rights I just talked about, but there is no statutory or legally written basis, law written, adopted by our legislature for a right to a speedy trial in the district court. But if you're up in the circuit court, that period is 180 days or 6 months from one of the following dates, either your first appearance before the court or your attorney's entry of appearance. So let's say you're already in jail on the district court. Your case is indicted up to the circuit court. Your attorney enters on January 1st. 6 months later, your Hicks date is there. And what does it mean? What happens if the court doesn't give you a trial within that 180 days? Well, your case could be dismissed. I say could be because there are always exceptions. And the exceptions for Hicks are for good cause found. So there needs to be a finding, meaning there needs to be a hearing with a judge who says, this is good cause. I'm going beyond the Hicks date. Or you need to come into court and say, I'm going to waive my statutory 180. I need more time. My lawyer needs more time. They need more time for a deal. Whatever the basis is, if you give it up or the judge finds good cause before the 180 days, then you don't have that right to a dismissal. But if you don't, even on that 181st day, the case can be dismissed. And there have been cases here in Maryland as recently as 2023 that have been dismissed. Homicide cases, first-degree murder cases, dismissed for going beyond that 180-day deadline. But it's only a violation if your lawyer makes a motion. So that's why it's important to not only know your rights, but pick counsel who's familiar with and understands the intricacies of constitutional speedy trial, but also statutory speedy trial. So, in sum, there are two bases from which to derive your speedy trial rights. The Sixth Amendment of the U.S. Constitution, Barker v. Wingo, and the statutory side of things, your Hicks date, Maryland Rule 4271. If you've got a case in Maryland, we'd be happy to help. Please give us a call. We'd be happy to consult with you. These are very fact-specific motions. So if you're watching this video, you can give us a call here at Frizalone. We may be able to help. Thanks and good luck.